Good afternoon. Mr. Chasty, I think we're ready to resume, thank you. Hold on 1 second.
I'm afraid that I'm not getting any sound. I'm just going to leave this meeting and rejoin. That sometimes does the trick. Sorry.
The rest of us will just pause for a moment.
Could someone say something? Just
yes, I'll say something. Can you hear us?
Okay. Yes, I can.
Okay.
Thank you very much.
So take two, Mr. Chasty.
Thank you very much. I'd like to go now to the judgment, but before I do, just to set the scene in relation to this question of dividends, which the judge seemed to place a considerable degree of store upon. Could I ask you to please to look at page 1645? This is a letter, another letter from Harney's. This is the 10th of April. This is in response to a letter which had been written by Conyers on behalf of the defendant, expressing concerns about paragraphs that I've already taken you to, 6 and 14 of the statement of claim, the original statement of claim, but not amended, in respect of the reference to dividends. And at 1645, Harney's come back and say this at paragraph 2. As clearly pleaded, the basis of our client's claim against the company and your client is that our clients have been deprived of their fundamental rights to information concerning the company to which they were concerned as members under the articles. And then 3, in the statement of claim, our clients did not plead any wrongdoing on the part of your client by reason of the company's failure to distribute dividends. Indeed, our clients are not in a position to assess whether they have any valid causes of action against the company or your client by reason of not having received any dividends, as our clients have been wrongfully denied of information concerning the company to which they were entitled under the articles and which would allow them to properly assess whether there's been any wrongful conduct. So absolutely expressly disavow any allegation of wrongdoing in respect of the dividends. And to make matters doubly clear, as it were, Ronald, in his witness statement at page 1485, at paragraph 43 and 44, notes that in addition to not having any financial information, neither he nor his siblings had received any dividends. But then at 45, he says, for the avoidance of doubt, I wish to point out that the claimants are not presently pleading any wrongdoing on the part of the defendants by reason of their failure to distribute dividends to us. Indeed, the claimants are not in a position to assess, etc. Essentially a repetition of what's contained in the letter from Harney. So that's how the case is put at trial, that they reserve their position to complain about dividends and non-payment once they see the financial information. The judge appears to acknowledge that initially in his judgment. If I could take you, please, to the judgment again, and this is at page 100 at paragraph 47. At paragraph 47, the judge said, under the heading no dividends, the claimants submitted that without the financial statements, the claimants have been unable to know whether the years of non-payment of dividends by the company was justified. And he says at 48, that was the nub of their complaint as it relates to dividends. It was not that they've not received dividends, but that without the financial statements, they can't determine whether the company was in a position to pay dividends and whether it should have considered paying dividends or whether it should have paid them. They submitted their being unfairly deprived of the information to know whether there were good reasons not to pay dividends. And that, so far so good in terms of him saying, well, that's how dividends comes into the equation, so far as it comes in at all. It comes in because they don't have the information to know whether they can make an allegation, and they've reserved their position. But in our respectful submission, rather oddly then, having correctly identified the limited issue in relation to dividends, matters then developed somewhat unsatisfactorily from my client's perspective. And you get the first hint of that at 53, paragraph 53. He says, the second defendant never explained or justified why dividends were not paid, or that as sole director he ever considered whether the company should pay dividends. And my answer is, well, he wasn't asked to. He wasn't required to in the context of the dispute. That no dividends had been paid. No dividends had been paid since 2006 at least, and can't give you the exact details on this, but I don't think ever. And no complaints had been raised. No requests for dividends had been made. And he was told on 2 occasions, were not alleging wrongdoing in respect of dividends. The matters then start to spiral a little bit, as it were, in terms of the judge's concern about dividends. He then says at page 113 at paragraph 120, the claimants did not receive a dividend from the company since 1994, if ever. That's the point that I was just seeking to make. Focusing on the period from May 2006, when the second defendant resumed control of the company, its business and affairs, and the claimant ceased to have access or be provided with any financial information, the company never paid a dividend, and that there was no evidence that the company ever considered whether it was commercially possible for it to distribute profits by way of dividend. Well, quite. No, there wasn't. There wasn't any evidence. There wasn't any need to address what had been described by Harney's effectively as a holding position. But the judge keeps referring to this theme in increasingly critical terms. Then if you go at 144, paragraph 144, he says at 144, the company's failure to provide financial statements in each year from 2006 was not for the benefit of the company or for any proper purpose, but rather for the improper benefit of the second defendant, including to keep from the claimants and minority shareholders information about the financial affairs, operations and state of the company. And then brackets, and then the last lines, and its ability to pay the dividends and the value of the claimant's shares in the company. So he jumps to a positive conclusion that the motivation in withholding the financial information was so as not to provide information which would enable them to know whether dividends were not being properly paid. But that wasn't even alleged in relation to this issue. Then again at 171, he says the similar thing at 171, as found above, the failure to provide financial statements to minority members in each year from 2006 was not for the benefit of the company or for any proper purpose, but for improper benefit of the second defendant, including to keep from the claimants and other minority shareholders information about the financial affairs of the company, skip brackets, and its ability to pay dividends. And this becomes more focused in terms of then, once he returns to the remedies, which he starts at paragraph 198, he then says at 201, and I need to come back to this 201 probably, but he says here, however, in this case, those orders, that's say a less extreme order than a buyout, are insufficient to deal with the oppression, unfair prejudice and unfair discrimination, and alone are not just inequitable to the claimants. They cannot alone remedy the unfair prejudice or deal fairly with the situation which has occurred. it's not always easy to know what actually is the unfair prejudice which he feels has occurred, but I'll try to come back to that. And then he says at 207, so forgive me, at 206, he says that my client has misguided beliefs about shareholder rights and his attitudes are too ingrained, and that he has a pattern of defending the indefensible and hardball tactic. 207, the reasons include, first, the second defendant's unjustifiable failure to provide the financial statements over many years, even when asked, and then all the claimants, and even when he had access to them in discussions with the second claimant about an acquisition of her shares. And second, the second defendant's long and strongly held misguided perspective that the claimants were not entitled to the economic benefits of their shares, as they were given the shares and as they did not work to build the company, as did the second defendant. That seems to be a suggestion of a deliberate withholding of dividends on the basis of, on assuming that economic benefits is meant to be a reference to dividends. 208, the court has no confidence that the second defendant will comply with his obligations to the claimants or will cause the company to comply with its obligations to them. He doesn't actually identify what obligations in particular he seems to be thinking about there. But then at 209, he said, after 2 years of litigation, the availability of high quality legal advice, the second defendant has never suggested to this court that he's seen the light, that he appreciates the legal requirements associated with, as an important example, consideration of the payment of dividends. That being so, objectively, how can a minority shareholder or this court have trust or confidence in him or in the company under its sole management? So what started with an express disavowal on the part of the petitioner saying, we are not making any allegations of wrongdoing in respect of the non-payment of dividends, seems to, by paragraph 209, have come to the basis of a conclusion that a clean break is required because my client will not comply with his obligations to pay dividends. So he's brought into account in our submission a factor, and indeed appears to have used it almost at the forefront of his reasoning and thinking to justify the order, which he never should have done in our submission. He identifies a failure on the part of my client to address matters without acknowledging or at least giving credit to the fact that Harney said in their letter and Ronald said in his witness statement that they were just reserving their position. In relation to delay, just to go back in the judgment to 35 for the moment, just to, I think, try to see what the judge was talking about when he used the phrase little or no relevance. At paragraph 34, he said, in the period March 04 to May 06, as a result of the Hong Kong judgment, the claimants and the other sibling who brought the Hong Kong proceedings were directors of the company with a receiver appointed by the Hong Kong Court of First Instance. In the course of the claimant's period as directors, and in particular in the latter part, certain things were done by them which were inappropriate and were remedied by them in about 2006, shortly after they occurred. Just in passing, they included, as I've already, I think, alluded to, payment to themselves of sums of money in breach of Hong Kong court orders and allotment of shares in breach of court orders. 36, the defendant raised those actions in this proceeding as reflecting on the character of those involved in going to the second defendant's concern about the claimant's motivations in relation to the financial statements and as going to their entitlement to the discretionary relief. While those actions don't reflect well on those involved, they are of little or no relevance to the central issue. So it seems and says, forgive me, in particular, they didn't justify the second actions in relation to the financial statements. It seems that what he said had little or no relevance was any reference to the claimants, the petitioners' misconduct in the context of what they did between 2004 2006, not addressing there the question about their complete failure to make any complaints at all about any of the matters that they're now complaining about in the 20 odd or 30 odd years or so while those events were taking place or those emissions were occurring. And then going back to paragraph 198, that doesn't feature at all, that fact. Not only does he say he doesn't give it any little or no relevance, he doesn't comment on it at all, although he has at least acknowledged at paragraph 196 something that we said at trial as to the, I don't know if I used this phrase or not, I probably did, extraordinary delays in making any complaints. He acknowledges at least the argument at 196. But then going back, if I may, to 188, trying to find a thread, if I can put it that way about this. At 193, he says, even if the financial statements do not indicate that any possible misconduct on the part of the second defendant may have occurred or be occurring, the claimant submitted that they will be at the mercy of the second defendant going forward if no court ordered buyout, if there is no court ordered buyout. I'm not sure what was meant by at the mercy as such, but then there is a reference at 199 to grace, which I've already taken you to. But then you can see at 200, there are orders that the court can make and makes below which meet the requirements for remedies discussed above and which this court thinks fit to deal with the legitimate reasons for the claimants to be provided with financial statements and to prevent a recurrence of their removal, of their right to financial statements. However, and I've read this 201, they're not sufficient, he says, to remedy the unfair prejudice which has occurred. 202, the court's entitled to look at the reality and practicalities where the relationship has broken down and there is a history of unfair prejudice. An order for the purchase of shares is much more preferable to orders directing future conduct. There is a history extending over decades. Well, first of all, he doesn't acknowledge or seem to recall that the relationship had broken down at least in 1994, if not before, and it has nothing to do as such with the management of the company at all, but is an unfortunate feature of the relationship of these siblings. He refers to a history of unfair prejudice. I'm going to come back to the amendments at paragraph 12 because it's difficult to know exactly what he's referring to there. And then he says there is a history extending over decades. But again, it's difficult to know what he means when he says there is a history. There is a history of these siblings, unfortunately, not getting on. But that could not be a justification for a share purchase order in our submission. Then he says at 203, in this case, beyond the resolutions, on an objective assessment, the claimants reasonably, legitimately, and justifiably lack of trust and confidence in the future management of the company and in his future conduct as far as they're concerned. As noted, assessed objectively, they're justified in that lack of trust and confidence. But again, he doesn't anywhere acknowledge that for 30 years, well, since the 1990s, apart from 2004-06, they have left it completely to the defendant without any question, without any request for information to manage the company. 204, the court agrees. 205, there's a real reason based on all that has occurred that the second defendant will not serve as sole director without occurrences. Again, it's not clear what is meant by all that has occurred. He then talks about the indefensible position and so forth. I've then read you 209 already. He then talks at 211 of the personal animus that the defendant has for the claimants. And then 213, for over 35 years, on both sides, there have been disagreements and disputes, behaviours that an objective observer might question, aggressive tactics, poor exercises of judgment, and no doubt disappointments, hurt feelings and bitterness. This is, with respect, rather difficult to actually make any reasonable or sensible, in our submission, analysis of, other than in saying these siblings don't get on. I think he's saying it might be as a result of both sides. It's been going on for 35 years, and he seems to think that the time has now come, because it's fair, presumably, for what he calls at 215 a trapped minority to be released from the company. But in our respectful submission, what was required in order to remedy the complaint that they were making was to order that the articles be changed back to what they were. To be noted that the judge actually had in mind even going further than that, but rewriting the articles to take out the possibility of, in the future, should circumstances arise, a waiver of the requirement. But nonetheless, what we say is a clearly proportionate remedy here was simply to rectify the wrong that had been complained of originally in the original set of pleading. They reserved their position to say, if we don't like what we see, we may come back, as it were. We may fight again if we think there's no justification for dividends. But the judge simply mopped up and threw into one pot, as it were, the fact that these siblings just did not get on, and seemed to reach the conclusion that that justified the more draconian order rather than the more bespoke order. But the reasoning is, in our respectful submission, wholly unsatisfactory. It brings in the dividend issue in a way that wasn't even promoted by the petitioners themselves when one steps back. And he makes no allowance and gives no reference at all to the fact that this is a situation which he seems to be describing, which the petitioners had tolerated for 20 odd years and provided no explanation as to why why matters had changed, other than to say they wanted to be bought out, they wanted to be able to negotiate from some position of knowledge, and we say they could, that those concerns would have been met entirely. Going back, there's not probably a great deal more I can say about this aspect of the judgment, where he refers to the history of this matter and a history of wrongdoings. This is where one just has to briefly perhaps go back to his judgment at starting at paragraph 59. He refers to paragraph 12 in a slightly complex way by calling them matter factors and dividing them into groups, but identifies them at those various subparagraphs A, B, C, D, and E. And I think that at E, when he refers to paragraph 12F of the amended statement of claim, he also intended to refer to paragraph 12E. I say that because of paragraph 63, which seems to suggest that when he talked about paragraph F, he meant paragraph E. He then addresses the positions of the parties, and then we seem to have a determination at 60, starting at 67. If I could just ask you please to look at page 105, 67. Matter factor A, which is the issue relating to the 18 million Hong Kong dollars and the 8 million in two tranches of 5 million odd and 2 million odd. He addresses at 69 and 70 an argument that we advanced, but he found no merit in respect of relating to subsidiaries, rather any transactions relating to subsidiaries rather than to the main company. But then he says at 71 that these transactions heighten concerns about the financial statements not being provided to the minority, so that the minority can raise legitimate concerns about the affairs of the company since May 2006. But as I've already stressed, and if need be, at the end, I can give you quick page references. These transactions related back to the 1990s, the early 1990s, and flowing through to the late 1990s. And it was clear that the petitioners knew about these transactions at the latest in 2005. So the issue about raising legitimate concerns about them had been in existence to the ability to do that had been in existence for 10 years. 72, second, these matters can be considered in the exercise of this court's discretion in respect of the remedy and relief, and should be considered together with other evidence supporting a court-ordered buyout. While they may have been and may continue to be oppressive, etc., this court can and does determine the liability issues in this proceeding without giving weight to those specific factors as conduct that was oppressive, unfairly, or unfairly prejudicial. I think he means that they're not in themselves unfairly prejudicial acts, but there's something that he will consider in the context of remedy, but makes no mention of the fact that the petitioners have known about these matters for years. Then he goes on at 73, with respect to the second defendant taking inconsistent and varying positions relating to the aspects of the affairs of the company raised as a matter factor B, this court considers, despite the points raised, these matters reflect negatively on how the second defendant maintained the records and handled the affairs of the company and is likely to do so in the future. All that this relates to is the fact that in respect of some transactions whereby the petitioners have themselves benefited from payments sometime in the very dim and distant past, the defendant had called those a gift and then subsequently had called them a loan. But no proceedings have ever been commenced or suggested as being brought against claimants in respect of those transactions by or on behalf of the company. And then D, E, and F, he says this court does not consider it appropriate to give weight in the proceedings the matters D, E, and F focused on by the second defendant. With respect to D, given the appellant outcome, but even without it, it goes too far to say that those findings made over a decade ago should be given any material weight. That was the findings of the Hong Kong court. So, although he seems to think that something 10 years old should be discounted because it's 10 years old, that doesn't apply in his reasoning in relation to anything else. And then he says why the other matters are irrelevant. And then then dealing with the siblings who sold their shares to my client, 81, I think this is where he's dealing. The claimants asserted that the second defendant took advantage of the other three siblings' lack of information about the value of the company and their shares when he acquired them without having the financial statements for the period and hear evidence about the three transactions. This court can't make a finding that the second defendant took advantage per se. save for the finding below regarding the financial information the second defendant as the purchasing member had, which the vendors lacked, this court can make no further finding of wrongdoing in that regard. The claimants complained that the second defendant's admitted appropriation for his own benefit of monies that the three selling members owed to the company was improper. And then this is the totality of the evidence on this sentence. I deducted in 5085, I deducted their shareholder loans and the outstanding share capital that they owed to the company and the value of their shareholdings. No justification or further explanation was provided in the evidence or by counsel for the second defendant. And then he says, 86, the effective result in economic terms must have been that the claimants involuntarily partly paid for the purchase prices. This was wrongful conduct. But there was no investigation at trial as to the level of any such impact in terms of wrongful conduct as to amount, because that one sentence is all there was. It featured then in the amended pleading. The claimants did nothing to advance the point beyond that one sentence. So we have no means of knowing, and the court didn't investigate the level or the extent that this issue had any bearing. And that seems to be the analysis of the allegations of wrongdoing. And then going back to what I started with, you have those paragraphs that I've already read, which talk in the most general terms, for example, going back to 202, as to a history extending over decades. But it's impossible to, in our submission, to know what it is that is being used to justify the contention or the conclusion that the more bespoke remedy that we identify as being appropriate is inappropriate. And I'm sorry, at the pains of, really I'm at the pains of repetition now, no question even, rhetorically, well, why didn't the petitioners do something about this earlier, about this history going over decades? And it rather looks as if what has happened is that, and what the judge ought to have considered is, there had been a satisfaction, or at least a tolerance, by the end of 2013 of a status quo which had been created. There was then a chance meeting after 15 years between Bertha and my client over dinner, where it appears as though the suggestion surfaced of Bertha selling her shares to my client and wanting some information. That was followed up in the email. It was then followed up in quite a, if I may say, aggressive letter, in the sense that all these years had passed. Harney's wrote and said, we demand information, and failure to do so will commence proceedings in 14 days. That was then followed by the change to the articles. But in our respectful submission, if one just steps back, one can see in our respectful submission, it's clear as day, that all that was required was to put the claimants back to effectively the status quo which had existed immediately prior to the dinner that took place in 2013, where they get their Article 120, but they never choose to do anything with it. But they also get the last 10 years since 2006 balance sheet, profit and loss account. They're then exactly in the position that they say motivate them in bringing the proceedings in the first place, where they can see what the position is, and they can then seek to negotiate if they wish their share. And in our very respectful submission, it really is as simple and short as that. And the judge clearly fell into error in taking into account irrelevant factors and failed to take any account at all of highly relevant factors, which is that very status quo which had existed. I'm not going to repeat the references in our written case to the authorities, and in particular those authorities dealing with delay. The delay in our submission must be a factor both in the context of whether or not you get through the first threshold of establishing a valid petition on the grounds of unfair prejudice, and in our submission remedy. And I think, as it's put in Hollington, unfair prejudice petitions should not be used as an excuse or a basis to rake over old grievances. I think that's how it's put, and we would respectfully adopt that sentiment and expression. We also referred you to the authorities in terms of the remedy should look, at first at least, to match the complaints made, and is not to be used as a punishment over a defendant. So I ask you, please, to bear in mind those authorities. I said that I had some references to give you. If I could do that just for reference points, and I won't give you everything, or else the list would get very long. But in terms, for example, of knowledge about the 18 million and 5 and 2 million Hong Kong dollar transactions, so I can put it that way. At page 1933, there is an email of the 17th of March 2005 from Ronald, where he is seeking to pressurise Mr. Robinson, the receiver, to bring proceedings against my client to seek the recovery of those sums of money. Very quickly, I can give you some other references. 1929, where there is a letter of the 11th of March to Ronald from the receiver, making it clear to Ronald that he's already had the letters that the receiver has himself been generating. In the transcripts, acknowledgement that the 18 million goes back to the period 1993. That's at page 410. And in relation to the 8 million, reference to page 433, showing that 437 goes back to the mid 1990s. In respect of the other complaints under paragraph 12, in relation to the fact that in 12A and 12B, the differences, the varying descriptions, yes, in 1992, Lawrence called one of the transactions a gift, and that's page 395 to 401 of the transcript. In relation to the transaction with the siblings, Ronald accepted in cross-examination at page 426 that he was aware of that at least 2 years before the proceedings were commenced. Obviously, they were aware of the views of the Hong Kong court when they were expressed in 2004. And in our submission, there's little in the paragraph 12 relying on an expression of desire on the part of my client to buy shares. Although it's fair to say, and again, transcript at page 429, that Ronald accepted that prior to the commencement of proceedings, my client had never expressed a desire to buy Ronald's shares. He'd only ever expressed a potential interest to buy Bertha's. And therefore, I could go on in terms of references. The final point that I would make is that the Ronald and Bertha, the third claimant, didn't give any evidence at all. So we know really little about his understanding or views or concerns. But Bertha and Ronald both accepted that the only reason they were asking for information in the correspondence in 2014 was they wanted it to be able to negotiate from a more informed position as regards the value of their shares. I can give you those references briefly. The transcript for Ronald is at 312 to 314. And for Bertha, it was 525, 526, and 537. And so those concerns that they themselves said they had are readily and easily met by the order that the Court of Appeal said was the appropriate order. I don't think I've taken up my full allotted time, but there's nothing further in the absence of any specific points you may wish to raise.
Can I just ask you this, please?
Yes.
Do we have the correspondence that deals with why the financial statements were not produced in the run-up to the hearing?
Yes, that's contained in various places. It starts at page 1588, and then if I can just give you these references, if I may, 1588, 1590 to 1594 is the lengthy Conyers response. The resolutions, there were two resolutions which changed Article 120. The first is at 1637, 1638. You then need to look at 1639, 1640, 1642, and then the letter that I showed you at 1645. And then finally, I think, 1647, 1648. I think that completes really the suite of correspondence that was passing. There were some requests for the memo and arts and some other formal corporate documentation which were satisfied and were met. And there is some toing, if I can put it this way, some toing and froing in terms of the positions being adopted in respect to the request. But I think that's as far as that correspondence goes.
Thank you.
I should perhaps just make this final point that you will of course be aware that there was quite a large part of the trial and parts of the judgment reflect the fact that there were arguments as to whether or not the change to Article 120, taking out the requirement to provide information, could be justified. It's wrong to say that if this is a lasting impression, that my client didn't try to justify the change to Article 120. He sought to do that on the basis of a legitimate use of that power within Article 120 on the grounds that he was exercising that power reasonably for the benefit of the company. And again, without taking you to the detail on this, because it isn't a direct issue in this appeal, he deals with this at paragraph 66 of his witness statement, where he seeks to say that the sudden interest after all the years that had gone on of silence on the part of his siblings in asking for information concerned him, especially against the background of the litigation that had gone on from 1999 to 2007, and that the provision of further information was going to result in a further round of litigation. That was his justification. That wasn't accepted. That was appealed to the Court of Appeal, the rejection by the judge, and the Court of Appeal said that they agreed with the judge on that. So that isn't an issue, and I'm not seeking to advance or raise that point, obviously, at all, other than to say you will, of course, be aware that some of that features in the judgment. With the greatest of respect to the judge at first instance, it's not always easy to know from the judgment when he's addressing that argument and when he's addressing other arguments that perhaps to some extent might be said to overlap. But I just make that a final comment. But subject to that, those are our submissions.
See whether anybody's got any questions for you. No, I don't think so. Thank you very much indeed, Mr. Chastity.
Thank you.
We come back to you, Mr. Parker, then for your reply, please.
Thank you. You very helpfully alerted me, shall I say, to the Piglowski Authority and the reference, which you may or may not have found, 1999, first volume of the Weekly Law Report, page 1360, and the relevant passage is at page 1372, letter E. Now, in terms of learned friend submissions, I confess I had difficulty at times in discerning what was argument arising on the appeal, given the decision of the Court of Appeal and the way they arrived at their decision, as compared to my learned friend seeking to re-argue the case. And I alluded to it before, but just to be absolutely clear, in my learned friend's written case pursuant to Rule 25, on page 2236, specifically asserts in paragraph 2 that the second respondent relies on the grounds set out by the Court of Appeal for allowing appeal and does not advance any additional or separate grounds, which is obviously particularly pertinent. My learned friend's submission about the trial judge's response to A, the non-payment of the dividends, and B, the claimant's expressions of concerns in circumstances where that's allied with a refusal of financial information. So my learned friend appeared to seek to justify the Court of Appeal's failure to have any regard or mention of the second respondent's financial misconduct on the basis that it was, quote, very old and that it was known about. But obviously, the irony of that submission is obvious, because the same is exactly true of the appellant's misconduct, in that that also was old and it was also known about. And yet it was only the appellant's misconduct is mentioned by the Court of Appeal. And I've already referred to the fact that that is odd, given that the appellants paid back the money that they took, and yet the second respondent has never paid his back and is still in a position to extract monies. And indeed, the monies that the second respondent has had the benefit of are greater than those which the appellants took and repaid. The second point is my learned friend refers to the fact that the breakdown in the relationship preceded the unfairly prejudicial conduct. But that doesn't alter the fact that when one goes on to consider the remedy, given the finding of unfairly prejudicial conduct, the fact that the relationship between the parties is one that has broken down is very relevant to the issue of the grant of relief. And it's relevant and because it increases the likelihood of future disputes. And my learned friend referred to my Lord Briggs's decision in Sikorsky. But there, my Lord Briggs emphasised that the remedy that he was granting was on the basis of no likelihood of future disputes. Then my learned friend sought to say that the starting point of the usual order, as described in Grace and Baggio, was on the basis that it was only a usual order in exclusion of management cases. That, of course, is a complete misreading of the decision in that case, because in that case, the alleged unfair prejudice based on exclusion from management was rejected. It was there that the exclusion was entirely justified. So the remedy was a response to unfairly prejudicial conduct consisting of the non-payment of the dividend. And the buyout was ordered on that basis. And you will recollect, it's paragraph 83, that the Court of Appeal made the point that precisely because there were grievances on both sides, with fault on both sides, and because the appellant did not have a place on the board, having been justifiably excluded, that there were reasons for a buyout order being made and not against. A fifth
It was a quasi-partnership, wasn't it? It was a quasi-partnership.
Yes, it started out as a quasi-partnership and there was joint management. But the complaint about effectively the end of the quasi-partnership by the exclusion from management, that was rejected because circumstances had changed. By seeking to acquire a competing company in the Far East without the consent of the other quasi-partners, he forfeited his entitlement to continue in joint management as a quasi-partnership. So that was no longer pertinent to what remedy to give. And the remedy was granted on the basis that the active remaining extant part of the case was a complaint about non-payment of dividend, which of course, in the circumstance of that case, the dividend was to be calculated in a particular way, but the fundamental complaint is one that all shareholders can bring, irrespective of any quasi-partnership, that they're entitled to a dividend if it's commercially practical for one to be paid.
That wasn't the case in this case, because there were no allegations about dividend policy. And in quasi-partnership, if I just go back to that, Lord Wilberforce was careful to say that the indicia which he produced were not conclusive or comprehensive or necessarily present in every case. And I can give an example where it wasn't. But on the dividends point, it was not part of your findings of unfair prejudice, and it had no relationship with the point on which you did succeed.
Oh, entirely accept that. I was seeking to rebut my learned friend's submission that the usual order of a buyout is only in cases of exclusion from management. And he cited Grace and Bagshot as being an example of that. What I'm saying is, it isn't. It is not saying the usual order is only in case of exclusion of management, because that case was not an exclusion from management case.
But if it was reformulated to say it was the usual order where there had been a breakdown in trust and confidence in circumstances where the court would imply equitable obligations beyond those set out in the articles as per Westbourne Galleries, would you then accept that it was correct?
No, I would not, because the overlaying of the equitable obligation arising from quasi-partnership were not pertinent to the Court of Appeal's grant of the remedy in that case. They were granting the remedy that they did because of the breakdown in the relationship, which meant that the appellant couldn't expect to be treated fairly going forward. They said the lengths to which the respondents had gone to ensure he did not receive the dividend that he was otherwise expecting, it being the dividend any shareholder is entitled to expect it, showed that there would be difficulties in the future. And we say that's what this case is about, because having highlighted the refusal to give financial statements in the context of never having been paid a dividend, the second respondent went out of his way, foolishly, we say, but that's what he did. He went out of his way to say, these appellants, all they want is money, even though they're not doing any work. And he constantly referred to the fact that they'd had the shares as a gift, even though he had himself. And the judge's evaluation of that evidence was that this was a person who was incapable, because of the view he took of the minority, of discharging his duties as a director.
But was that allegation ever squarely put to him in the pleadings?
It couldn't be put because he didn't give evidence.
Well, if you're making an allegation that a person can't be trusted, it's usual to make it part of your case. But this is the judge making an inference from what was before him, which had never been pleaded by the parties.
Well, it had never been pleaded, but one has to be careful here. All the circumstances of the case is what the court is entitled to take account of when deciding on the relief. The defendant runs as an unpleaded defence that he was justified in not giving them the financial statement because they are mischief makers who want money even though they're not doing any work. That was his defence. It was unpleaded, but it was his defence. And the court took account of that to effect saying, well, in the court's evaluation, this is a respondent who is saying, I'm not going to pay the money because they don't work in the company. And we said, well, that's effectively the definition of a shareholder, a prima facie entitlement to money, even though they don't work in the company. And that's the point that the judge made absolutely clear in paragraph 217 that we looked at. But this is a relevant circumstance of the case arising out of what the respondent himself said. And therefore, it is, in my submission, it's very much beside the point on the question of remedy, that this wasn't something that the claimant pleaded itself, because this arises out of the defence that was run at trial. And I obviously reiterate, no challenge to that. And that's because the findings of fact and the evaluation of the evidence is a matter for the trial judge. I was just pointing out that the question of no-fault divorce is obviously, it's only relevant in circumstances where there is no proven fault. And obviously, in this case, there was proven fault. There was unfair prejudice that the Court of Appeal described as egregious. The fact that the relationship in question broke down before the egregious unfair prejudicial conduct, it doesn't alter the fact that it has exactly the same effect when one gets on to consider the likelihood of future disputes.
But could I just ask you this? Just suppose, and I'm not giving a view, just suppose that the Court of Appeal were right to say the judge should have taken into account that they had made no complaint up to 2013 and known about a number of specific matters which might be said to be wrongdoing. If they could not take those into account, why should these matters be taken into account at the remedies stage? If they're prevented from relying on them, why was the judge able to bring these matters up and say, well, this is obviously a director, if I may put it this way, who cannot be trusted?
Because it shows what the respondent is capable of. He took money. He took money out of the company which he hadn't repaid. Now, you can say to a potential petitioner, you've sat on that for too long. You're not coming to court and taking your court time because that horse has bolted. So the focus is on the conduct of the petitioner at that point. But when we're talking about the remedy, the focus is on the conduct of the respondent. This is a man who took money. This is a man who's never paid it back. This is a man who makes no apology for having taken the money. That's pertinent to what might happen in the future.
Thank you.
Now, my other friend criticised the judge's treatment on dividends. Well, all that the judge was conscious of is allegation that no dividends had ever been paid, and the second respondent's response to say, but these are people that simply want money even though they're not working for the company. And the judge simply stated it as a fact, which was a fact, that there'd been no evidence as to why dividend had not been paid. Because, as you saw from paragraph 14, the claimants are saying, well, we've got concerns, but because we don't have the financial information, we can't actually plead the facts behind a complaint about non-payment of dividend. And the judge simply noted, well, that's true enough, because the defendant has chosen to remain silent on the topic. But principally, my point on this wasn't, the Court of Appeal didn't say there was an error of principle by the trial judge in the way in which he addressed the question of dividends. The error of principle that they identified was the alleged failure to have regard to the conduct of the appellants. And I was going to finish with the point I've already made in response to Lady Arden, that the second reason arose from what the defence was, the unpleaded defence that was run in an attempt to justify the continued refusal, which carried on throughout the proceedings of withholding of the financial information. Thank you very much.
Thank you very much indeed. I wonder if anybody's got any more questions to ask. No. Well, we're extremely grateful to the parties for making their submissions for the case today, and also, of course, to everybody else who's been assisting. We can't see them all sitting behind you in the present circumstances, but we are grateful to them as well. And we will now give consideration to our decision. Thank you all very much.
Thank you.